Welcome to EUPrivacyForAll, Session 15 on GDPR, Article 11, Processing not requiring identification. The final numbering of the article related to processing which does not require identification is Article 11. In Article 11, it is laid down that if the purposes for which a controller processes personal data do not or no longer require the identification of data subject by the controller shall not be obliged to maintain, acquire, or process additional information in order to identify the data subject. Where the controller is able to demonstrate that it is not in a position to identify the data subject, it shall inform the data subject accordingly, if possible. In such cases, for the purpose of exercising the data subject's rights, the controller shall accept additional information enabling the exercise of such rights. Recital 26 lays down other key principles. First, that the principles of data protection should apply to any information concerning an identified or identifiable natural person. Personal data undergoing pseudonymization should be considered to be information on an identifiable natural person. To determine whether a person is identifiable, account should be taken of all the means reasonably likely to be used, such as singling out, either by the controller or by any other person. The costs and the amount of time required for identification and the available technology at the time of the processing and technological developments should be taken into account. The principles of data protection should therefore not apply to anonymous information, that is to say, information which does not relate to an identified or identifiable natural person, or to personal data rendered anonymous in such a way that the data subject is not or no longer identifiable. Other provisions in the GDPR are laid down in Recital 57. The data controller should not be obliged to acquire additional information in order to comply with the regulation. However, it shall not refuse to take additional information provided by the data subject in order to support the exercise of his or her rights. And identification should include the digital identification of a data subject, that is to say, authentication mechanism such as data subject's login and online services credentials. Recital 156 stresses the fact that the further processing of personal data for archiving purposes, scientific, historical, or statistical purposes is to be carried out when the controller has assessed the feasibility to fulfill those purposes by processing data which do not permit or no longer permit the identification of data subjects and provides appropriate safeguards. In Article 4.1, defining personal data, it is made clear that it means any information relating to an identified or identifiable natural person, the data subject. Article 5.1e makes clear that personal data shall not be kept in a form which permits identification of data subject for longer than is necessary for the purposes initially identified. In Article 89 on safeguards and derogations relating to processing for archiving purposes in the public interest, scientific or historical research purposes, or statistical purposes, it is also laid down that processing for those purposes shall be subject to appropriate safeguards in accordance with this regulation, that is to say, ensuring that technical and organizational measures are in place, and in particular in order to ensure respect of the principle of data minimization. Among others, Those measures include pseudonymization, and additionally, where those purposes can be fulfilled by further processing of data which does not permit or no longer permits the identification of data subjects, those purposes shall be fulfilled in that manner. The directive applies to any information concerning an identified or identifiable person. To determine whether a person is identifiable or not, account should be taken of all the means likely reasonably to be used. Additionally, codes of conduct framed by Article 27 of the Directive could be used to give guidance on the ways that could be used to render data anonymous. Definition of personal data and the fact that it shall not be kept in a way that would allow identification of a person longer than necessary is also laid down in the Directive. What should accountable data controllers and processors get prepared for? First, sticking to the core principle laid down in the Directive, stressing that all information directly or indirectly allowing to identify persons fall within the scope of the regulation. Second, taking due count of the fact that the identification of data subjects shall not be longer than necessary. Refraining from maintaining, acquiring, or processing additional information just for the data subject to be in capacity to exercise their rights. In such a case, data subject would specifically provide additional information. De-identify data whenever it is possible, notably using pseudonymization mechanisms. Bear in mind that identification number or online identifier enters the scope of processing information related to identifiable persons. Finally, assess rigorously whether a person is identifiable or not, taking account of two things. First, all the means reasonably likely to be used, depending on technology at the time of the processing, and then costs and amount of time required. EDPB guidance will be more than welcome on knowing how to differentiate what is still identifiable data and what is anonymized data.